Merci. Merci, Jean-Félix. We will hear now from Arnaud about the settlement of disputes in new EU FTAs, democratizing international adjudication.
Yes, thank you very much. I'm sorry for this word of democratizing. I realized that it was very difficult to say, actually, so I'll try to find another way. Just to react to my... I'm sorry if I have bothered you. It's just that I'm obliged to be like
you
this.
You can take my place.
It's fine. I totally agree with you. But in the case of that, let's say, nightmare scenario, I think the only solution would be to get back to the contract and to arbitration in contract. And I'm quite sure that if there is an incompatibility of the ICS with the autonomy of the legal order of the European Union, then we should get back to what was what happened in the 60s. And I think there is a real risk here. But, well, this is not my point here. I'm here so to speak about the settlement of disputes in new FTAs. And I'm here talking about settlement of disputes both in investment and trade matters. Because I think this is an interesting point here, is that those two kinds of disputes are submitted to two kinds of procedures, but they have common features. And I would say that this is maybe a new trend in international law, and a very interesting one. I just want to start with a very brief historical point, and just to recall that settlement of economic disputes may be the very origin of settlement of disputes in international law. If we get back to the 18th century, what is considered as the first international jurisdiction, that is the mixed commission that was set up by the Jay Treaty between United States and the United Kingdom. The Jay Treaty mixed commissions had to deal with many cases of property, many cases of expropriations, many cases of confiscations, and actually those commissions defined the first rules of international economic law. And then during all along the 19th century, states set up many mixed commissions that defined the rules of international economic law, and that really were at the origin of the international jurisdiction that were created during the 20th century, to put a long story short. So there is a link between international adjudication in general and settlement of economic disputes in international law, and we may have arrived at a new step in that history, in that sense that the new free trade agreements negotiated by the European Union may have introduced a new reform, a new kind of dispute settlement in economic matters that may actually reveal a general trend in international adjudication in general. And the main feature of that new kind of settlement of dispute would be this democratizing thing, in the sense that this would be more transparent, this would take into account in a better way general interest, it would associate civil society in a more general way. And I think we may here be at a moment of change, an important change in international adjudication in general, if we recall that international settlement of dispute is something kind of new in the manner that we see it today. Let's just recall that there have been those mixed commissions in the 19th century, but the first real permanent jurisdiction has been the Permanent Court of Arbitration at the beginning of the 19th century. Well, the development of international courts dates to the second part of the 20th century. So this is something new, and I'd say there are still in the course of an evolution. So I won't recall here that trade disputes are within WTO submitted to this dispute settlement body. Everyone is aware of that here. I will not recall either that investment disputes are submitted to arbitral tribunals, which are the evil we have to fight against. I may be the evil's advocate in some part here, because someone has to take this role, and I have to assume it a little bit here. But still, this is, well, what is interesting is that these new FTAs, if we take things broadly, I can't get into details here, but these new FTAs try to kind of merge the two kind of dispute settlement. And obviously, the international court system that you're going to talk about has a model in the dispute settlement body of the WTO that has proven to be quite efficient, actually, and that was criticized in the 90s, but that is not criticized anymore at all, because maybe the NGOs have forgotten it, I don't know, or maybe because it has made the job, and it has been progress in some aspects. So that would explain that this model has been taken into account by the European Commission and the European Union in general. So what I want to stress here is this process of democratization in general, meaning that by democratization, once again, I just mean this trend of opening to the public, this transparency requirements that are taken into account, the publicity of decisions, the publicity of briefs, etc. All that general evolution that we are assisting now in a transatlantic relationship. So what I want to do here, and I'll be brief because this is the end of the day, because this is the almost the weekend, and I guess everyone wants to discover the Rue Saint-Michel, and so I'll try to address first the general weaknesses of dispute settlement in economic law, so trade and investment, and then I will try to demonstrate how these weaknesses have been addressed by the European Union and Canada and Vietnam and Singapore and all the commercial partners of the European Union, just to show that there has been a shift, an important shift in the taking into account of this democratic concern. So first about the weaknesses. I'll be brief about the weaknesses because we've heard about a lot about them, not here, not that much here, but in other fora. So I'll try to be quick. First, the main criticism that is addressed to dispute settlement is the threat on the state's right to regulate. This criticism is almost always addressed to investment state dispute settlement and to arbitration, but we never hear this kind of criticism against trade disputes. Whereas I must confess that I think that trade disputes are really more threatening to the state's right to regulate rather than the investment state arbitration. Why? Because, well, I'm not here to address this question, but if we take into account, if we have a look at the practice, if we take a look at the case law of the WTO, the dispute settlement body, and arbitral tribunals, you can see easily that, in fact, I have no example of a state that has been held responsible for a general interest measure in front of an arbitral tribunal. You talked about the Vattenfall case, of course. Yes, there have been a judge that said that the investor was entitled to compensation, but that judge was the German Constitutional Court. So no one talked about it. If it had been an arbitral tribunal, this would have been I think a mess, but this is the Constitutional Court. If we talk about the Philip Morris Award, I just here recall that in Philip Morris versus Australia, the claim didn't reach the merits because the tribunal considered that the investor had made an abuse of process, so the claim was inadmissible, so it didn't go to the merits. In the Philip Morris versus Uruguay, the tribunal considered that the measure was plainly legitimate, that there was no problem in international law, so that it was not a violation of international law, so the company was not entitled to any compensation. So, I mean, I just want to recall this here, whereas if we take the WTO case law, if we take environmental purpose, for instance, of measure, it is taken into account by the DSB, but to my knowledge, I'm not a specialist of WTO, but to my knowledge, the environmental concern has never overruled the commercial concern. I think it has been taken into account.
In the asbestos case, for instance, the EU...
It reversed?
Yeah.
Okay, so it happens. But I mean, the shrimp case, in the biogas case, well, there are more condemnation of states for environmental measures in trade disputes than in investment disputes. Still, this is interesting to well, put this back into order, because I think this explains as well some criticisms. So that's the first point I just wanted to make very, very quickly. Second point, second criticism, that is the lack of transparency. It's right that the briefs of the parties are not always published. It's true that the awards and decisions are not always published, not in WTO, but in arbitration here. It's true that the hearings are not always public. And it is true that the non-disputing parties, so the amicus curiae issue is, the amicus curiae briefs are not welcome. Basically, in arbitration, and even in WTO, it's not always very easy to submit a brief when you are an NGO, for instance, if there is an environmental case. So that is, I think, a criticism that has to be addressed as well. And the third point I just wanted to make here is the lack of independence of the judges. And there is here a difficult point. Which is that in arbitration, especially, the parties are able to name their own judges. And this is something that is very hard to understand when you're not familiar with arbitration. And it's true that there is a kind of a concentration of the litigation, and that's there are always the same persons that are named by investors, always the same persons that are named by the states, because you know that he is more favorable to the state in general. So that is an issue that is not disputable. So anyway, those are the main difficulties that we face coming to settlement of economic disputes. And so what I want to see now is how those criticisms have been addressed and how these weaknesses have been taken into account by the free trade agreements, and how this may reveal a new trend in dispute resolution in international economic law. First point. It has been addressed, so I'm going to be quick on that. It has been the association of the civil society in the conception of the system itself. We have been talking about this, but in the TTIP, the European Commission suspended the negotiations in order to consult some NGOs and the civil society, and then to set aside arbitration and create this system of a permanent court. This is interesting. This is not without precedent, but the only precedent I can think of is the one of the International Criminal Court. That has been conceived by states, obviously, but with a lot of association of NGOs, civil societies, associations of victims, etc. And many specialists of international criminal law say that if there had not been this pressure of NGOs, there would not be ICC at all. So that's the only precedent I can think of, but this is interesting to draw a parallel between the two issues. So that's just a first point, and I think this helps to give more transparency and then more credibility to this kind of adjudication, because when you come to arbitral tribunals, no one knows from where they come, and this is a bad start. Here we have a good start, so this is a good point. Coming now to the state's right to regulate, I would just recall that here we have to distinguish between investment and trade disputes. In investment disputes, all the FTAs I have been looking at, which are not all the FTAs of the European Union, but they include a general provision recalling that a general measure of the state that is aiming at promoting the common good is not a violation of the agreement. Well, I'm happy to know it, but I knew it before. I mean, this is only a codification of a general rule of international law that is settled and non-disputable since maybe 2 centuries. So my point is that it's totally useless from a legal point of view. But this is a way, you know, to show that they have heard the criticisms. So let's introduce this provision. I mean, it's not totally useless, of course. I'm a little bit exaggerating, but still, this is not that important, actually. So, and what is striking here is that this provision, you find it in investment disputes, but there is no such a disposition or such a provision in trade-related issues. Whereas, I think that in trade matters, you can have exactly the same threats. You know, if a state adopts an environmental measure that has an effect of reducing some import of some kind of goods, and then the issue is the same, and you don't have this provision here. So, I mean, from a legal point of view, once again, it's not that important because there is a general principle, and all the jurisdiction will tell you that this principle is settled, it's customary, it's non-disputable once again. So it will be applicable to trade matters. But it's interesting to see that you have this provision in investment chapter because we have been talking only about investment chapter, but we don't have this provision in trade, the trade chapters, whereas I guess the issue is the same. So the state's right to regulate, I would say, is not that threatened in those mechanisms. When we come now, to transparency. Here again, there are a lot of things to address. I'll just select 2 or 3 points. First, about the opening of hearings to the public. This is a principle that is better, that has been introduced in trade disputes, except, of course, if the parties agree otherwise. So it means that the principle is that the hearings are open to the public, but the parties may still refuse it. So it means that the parties in trade disputes, so that the states, they may oppose to this opening. In investment dispute, there is no such a provision in the FTAs because the question depends on the applicable arbitration rule. Because the ICS will not have its own rule of procedure. It will apply the ICSID rule or the UNCITRAL rule, so World Bank or United Nations rules or any rule adopted by the parties. So it will depend on the arbitration rules that are usually silent about this. We can just say that there is a trend of opening hearings to the public. I must just stay here for having been a counsel in cases, so for having attended hearings, that it's not really fascinating. It's much more boring because it lasts like four days, and you can't raise and say objection, Your Honor. You know, it's not. There is nothing you can do interesting. So I'm not sure that the public will gain anything about this, but still, it's a good thing that it can be heard by specialists of international law. I think there is a trend here, but which does not come from the FTAs directly. When we come to the second point I want to address is the amicus curiae issue. You know, the amicus curiae is the possibility of getting some non-disputing parties brief. This is a huge demand of NGOs for claims involving human rights, involving environmental matters once again. Here again, we have to distinguish between trade and investment. In trade disputes, non-disputing party briefs are accepted in the FTAs in a general way. They are accepted, and the FTAs provide that there should be an acceptance of those briefs. Except that the panel members can refuse the brief if it considers that it's not relevant, and the parties can also refuse the brief if they consider that it makes no sense or it doesn't bring anything to the dispute. So this is an opening, quite a timid one, but still there is an opening. And in investment dispute, it's exactly like for the opening of hearings to the public, in the sense that it will depend on the arbitration rule that are applicable. But here again, there is a general trend of accepting those amicus curiae briefs. So there is here as well a general trend. Just a last point about transparency, the publication of decisions. I would say here that here again it will depend on the applicable text, but the issue is not that much the publication itself than the clarity of the decision. Because when you have to read an arbitral award, for instance, let's take the UCOS award that we talked about this morning. The UCOS award is like 600 pages, and 400 of them are devoted to compensation. So you have tables and numbers, and I mean, Okay, it is published, but who can read that? Except me, because I have to write about this. But I mean, there is here an issue. I mean, to say that it's published, it's one point. To say that it makes law accessible and to make law understandable by well, the civil society, I think here there is an improvement that could be made. So I don't want to take too much time. I just want to say that I could. Well, I could make other points just to say that there are some progress that have been made, and that show that we are really. I get back to what I said at the beginning. We're really, I'd say, at a shift moment, and dispute settlement has been construed in by step, and I would say really that this is a new step. I just want to finish by recalling that this general hostility towards international jurisdiction, towards arbitral tribunals in particular, is not specific to economic law. I just want to recall that once it is international, it will be criticized by states. Take the example of the International Court of Justice ruling in 2014 about Japan and the whaling case. In that case, Japan was held responsible for whalings, for a violation of the Whaling Convention. For the Japanese people, this was an attempt to a tradition. This was an attempt to sovereignty, and it has been very, very badly accepted. Take the example of the criminal jurisdiction in some African states. Some African states are now talking about denouncing the Rome Statute. So what I just want to say here is that this hostility is something that is inherent to international jurisdiction, inherent to international adjudication. So it doesn't mean that it has to disappear, and I mean it has to be improved. And I would say that the European Union make here a good step forward in this improvement, and we'll see what the future will be. But for this, I'll leave the floor to my colleague. Thank you very much.